All right, this is part 2 of our video series about the methods in which parents can make a parenting plan. As a reminder, we're not going to be talking about the substance of a parenting plan. Instead, we're talking about how we create the parenting plans. In our previous video, we briefly touched upon an agreement and then using mediation in an attempt to find an agreement. In this video, we're going to be talking about a guardian ad litem and a 604.10, also referred to as a 604B. Now, what is a GAL? A GAL is short for guardian ad litem. They are appointed by judges in family law cases to essentially become the eyes and ears of the court. They can go out and investigate things and report back to the court and ultimately make recommendations to the court. Now, it's really important that you understand right up front, they make recommendations. They do not make decisions. That still is the judge's job. Now, a guardian ad litem is tasked with doing investigations for the court, but they're always guided by the standard of best interest of the child, meaning their job is to always investigate with the lens of looking out for what's in the best interest of your child or children. They will investigate with you, with your spouse. They may meet with teachers, other professionals, anybody else who might be able to provide information that would lead to an ability for them to make a recommendation. There's not a cookie cutter approach and each situation is different, but you can expect them to reach out to you and to your spouse at the minimum, and then they will start reaching out to other witnesses who can help with their investigation. Now, what should you expect from a GAL? Again, this is like any lawyer answer, but it depends. A lot of times it's going to depend upon what they were appointed for. Are they there to make a recommendation on a limited specific issue, or are they given broad overview of trying to come up with a parenting plan from the start? Every situation is different, so you really should be speaking with a lawyer of your own, understanding that the GAL is not there to help you. They are there to help your children and ultimately the court. They don't work for you and they don't work for the other side. You have an attorney and you should be running things past your attorney before you give it to the GAL. Unfortunately, I have seen some clients make mistakes by offering too much information to a guardian ad litem when they should have used their attorneys to filter that information. Now, this may be done with the best of intentions, but it's really important that you use your attorney and recognize the GAL doesn't work for you and they are actually appointed by the court. Now let's talk about the GAL recommendations. Again, every situation is unique and different, and sometimes those recommendations may be in a written report, sometimes they may be in an oral report. It really depends upon the judge, the GAL, and the parties as to what is expected. Now, if you want a written report, that may be the best situation for your case. However, you should expect to spend more time and money to get that report finished. The reality is, if you're going to be paying a GAL to write a report, they're going to need some money to write that report, make revisions, make updates as appropriate. Whereas an oral report, they can simply do it in court and not have to pay for the time for revisions, writing, etc. Pros and cons of each, and it's really important that you speak with your attorney to determine what's the best thing for your situation. All right, the last method we're going to talk about in this video is a 60410. It used to be called a 604B, so if you hear an attorney refer to it as a 604B, they're one and the same. There was just a change in the statute. The substance is essentially the same. What we're doing in this is we're having a new professional appointed. This is going to be a high-level professional that has clinical training and evaluations. They're going to be running you and your spouse through some psychological testing. They're going to be interviewing witnesses, reviewing reports. Ultimately, they're going to be making a recommendation to the court, usually involving the custody or the primary caretaking functions of a child. And they could be making some other recommendations regarding maybe supervised parenting time or restricted parenting time. The bottom line is, this is as high as you're going to go before the judge ultimately makes a decision. This is very expensive. Typically, you're talking about a $10,000 retainer, give or take, for the professional. That doesn't even include the attorney's fees, the GAL fees, or any other fees associated with this case. Now, we know this is very expensive, but sometimes this is the only way that you're able to get the case and the evidence that you want so you can present it to the judge. All right, we hope you found this two-part video series helpful in describing the methods of creating a parenting plan. If you need some more information about how to create the contents of a parenting plan, please check out our other videos. If you need help with creating a parenting plan or you're going through this process, please contact our office. We'd be happy to look at your situation for you.